besides that, I've already mentioned that, I'm sorry, there was, since there is not the evidence that we wanted, the videos, that those were destroyed, and they were destroyed by UAMS, and you did have notification, you could have been reasonably certain that there was going to be litigation on this. And the other reason being that you're not providing any other um, like extrapolation on the record. And I've listened to a number of depositions, and they ask questions that, extrapolate upon what was in the record, the written record. So, we just want more information. And so, what we're asking for that would be, if we put the case into abeyance, and let my cases, which are so far uninsured, we would want to know all sources of insurance, including medical malpractice and general liability, because the general liability might cover my claims.
We do not have any general liability insurance.
Wow. Okay.
That is not surprising. We are a state agency, and the Arkansas State Claims Commission is the body that is assigned to hear those claims. So
Right.
rather than insurance that we would have to constantly pay for, if there is a claim that arises, it goes to the Arkansas State Claims Commission.
Okay.
So there's not a loss of remedy there. We just do not waste taxpayer money with insurance when the claims that go to the Claims Commission and are actually awarded are very few. And with all due respect, thus far you are still making your arguments for why you should be right in this case. I believe we have fully responded, and I cannot agree to pay for depositions when I do not believe that anything was destroyed after a proper notice of a threat of litigation. So that's a non-starter for us. I also believe that your claims are still intertwined with the medical negligence claims raised on behalf of Mr. Lynn, such that those claims could not move forward either. So it's our position all of these claims must be placed in abeyance pending the exhaustion of administrative remedies or insurance remedies in this case. And I think the Claims Commission is the body that's going to need to make that decision.
The other thing that we were asking for is that we want all the objections to be removed to prevent for an evidence ambush at trial. So, like, if you want to rest your case on just the medical record, which is what it looks like by your responses, then we don't want you coming back at some later time and saying that, you have these emails between two doctors that say that Sean was so uh, ready to die at any moment, because there's nothing like that in the record that says that, they didn't need to do surgery. All they were doing was observing him.
I am not aware of any such emails. The only records that I am aware of that are relevant to this case is the medical record. I am aware of no other records, emails or otherwise, that would be relevant. I've already reviewed every single request and response. I've changed and tried to provide additional information when I could, but I am not going to go through and remove any more objections at this point. I thought when you wanted to discuss possible resolutions of some of these issues, we might be able to do something like resolve the motion for protective order or, removing the motion to strike, because I don't see that any of these others, based on the position you're taking, can be resolved between the two of us without a decision by the Claims Commission.
Okay, and so on the motion to strike, what would be your proposition?
Well, case law indicates, and I didn't put that in my initial filing because I actually didn't realize you would disagree with our position that it was moot. But there's an Arkansas Supreme Court case from 2017 that is City of Little Rock versus Daeyoung Yang, and the
Oh,
site for that is 2017 ARC 18, page 7, and it states an amended complaint, unless it adopts and incorporates the original complaint, supersedes the original complaint. So your third amended claim has superseded the second amended claim, and so the only claim before the commission is the third amended claim and the answer thereto. The answer to the second amended claim is no longer relevant because that second amended claim has been superseded.
okay, so I'm a little confused because I thought that the motion to strike was to strike you put in the amended and substituted answers or responses
No, ma'am,
to
you filed a motion to
interrogatories.
strike.
What's that?
You filed the motion to strike, and my reading of it was that you were moving to strike portions of the answer. Yes, here it says, claimants moves this commission to strike portions of respondent's answer to the second amended claim. So what I'm telling you is based on Arkansas Supreme Court law, because in your third amended claim that you filed, you did not incorporate, and you have to use that language, incorporate the previous claim, then your third amended claim has superseded the second claim, and so the answer to the second amended claim has been superseded and is moot.
Okay. And the third answer doesn't say the same thing?
What do you mean?
What we were asking you to strike. I'll look at that.
I don't know. I don't know. You'll have to go back and reread the third amended claim and our answer and see what it is you object to.
Okay, so
If you
but
object to something and feel it needs to be stricken, then you need to file a motion to strike the answer to the third amended claim.
okay, and so practically speaking, and you're right legally that about what you're saying, that the third amended supersedes it, and I know that to be true, and I know that I need to, if I wanted to get around that, I would need to like incorporate it by reference. But practically speaking, which is what Sean was talking about, is that like I would just file the exact same thing saying they're still not answering us or they're still making an improper answer. But I will take a look at it and see if I need to do that. And then I'll file, I'll make the changes. I'll just like use the second amended complaint striking motion and I'll add it, I'll cut out the words second amended complaint and put in third and see how they differed. And so we'll go ahead and do that. But
Okay,
then that doesn't get rid of the problem. It's
well, I'm looking at your motion to strike
yeah.
and the language that you object to.
Okay.
And this is all part of the issue of fact that the commission's going to have to decide.
And so remind me, what's the language I object to?
You objected to the use of the term legal medical record, which I have explained what that means in one of my other responses. you object to the phrase medical treatment provided and to the characterization of Mr. Lynn as a patient. Now, obviously, all of those things are issues of fact with which we disagree. And so you're going to have to file a motion to strike that, but I will tell you the commission's going to come up with the same response. These are issues of fact that the commission is not going to strike from an answer until it hears the case. So it's up to you how you want to handle that, and certainly we will respond accordingly, but those are not items that I can change in the answer when that is a pretty significant change you're asking us to make, because we do not believe that Mr. Lynn was held captive here. We do believe he was a patient because of the traumatic brain injury he suffered, and we do believe that he was provided medical treatment while he was here. I understand you agree with all of that, but nothing that you have given me so
No,
far
I disagree with that.
changes my opinion on that. That's what I said. I know you do not agree with my statement.
Okay, I didn't
But
hear that.
nothing you have presented to us thus far changes my opinion, especially considering the number of these kinds of cases in medical negligence that I've handled over the years. So I'm sorry that we can't come to a resolution, but after November 7th and the commission's decisions, you can go forward and file a motion to strike if you so feel the need to. But I think you know where we stand on that.
Okay, and so what was the first one you mentioned? Because I went to the second. You said there was something else we could maybe.
Oh, the motion for protective order. I mean, you've said you've already released videos and audio of Mr. Lynn. I've assured you that UAMS has no intention of releasing any audio or video, but in your protective order, you insist that if something is labeled confidential, that only you and Mr. Lynn possess the right to change that without the commission's review. And so we disagree with that. If something is designated as confidential, then it should be confidential until the commission says otherwise.
Oh, so we do disagree on that. But our point is that, as a solid example, we marked a video confidential because it shows his genitals. Just very briefly.
I have no intention of showing that video to anyone outside of the folks that I need to work on this case.
And there's probably other protections. I mean, it would probably be like another lawsuit if it was exposed, to make a double entendre. But if he, we just want him to, and especially if all of a sudden they find the videos that were deleted or are able to reconstruct them, we don't want him to be unduly embarrassed by.
If you're talking about UAMS security videos,
yes.
There are no videos. There's nothing that can be reconstructed. I've told you time after time, the way that our system works is that after that period of time in the policy, it is automatically overwritten. There was absolutely nothing archived or preserved from Mr. Lynn's hospitalization, and there was not a camera in his room that would have been recording anyway.
Yeah, it was in the hallways too, though, and in the emergency department.
The videos do not exist.
Well, I don't understand why you have trouble then saying that you will keep the non-existent videos confidential.
There's no video for me to keep confidential. I've told you I would keep anything produced by your side with audio or the exception of anybody who's working on this case, which could be my paralegal or
Yeah.
any physicians that have to review the information in order to testify. What my objection is your one-sided decision making, that you can designate it confidential one day and then the next day say, no, never mind, we're going to release it because we want to target a UAMS employee.
Well, we're not trying to target an employee. We're just trying to keep things that Sean doesn't want on the internet because they're embarrassing, and we have already. He's allowed me to put up like just about everything, and the only thing that we've kept is the parts that we think are probably pornographic in a sense, showing.
And as I've said,
Yeah.
UAMS has no intention of making any audio or video files that you have provided public knowledge. They will never be placed on the internet or anything like that by UAMS.
Okay, so why can't you write those words on paper?
I have put those words. I put those words in the response to the protective order that we are not going to do anything like that. But like I said,
Okay.
what
Then
we will not
I guess if you did violate it, it would be like promissory estoppel or something. I don't know. Whatever it would be. I don't know. I haven't thought about it, but if you did violate what you wrote in the responses, I mean, that shows that your intent is to, like, we're making a verbal contract, basically.
We're not
But
making a verbal contract, but what I've put in the pleading stands, and the pleading says that UAMS has no intention of publicly releasing any pictures, videos, or audio files that you have provided in this case.
okay. Sean just let me know that you're obviously not going to.
I'm not going to what?
Post the
Release,
videos.
information?
Post the videos
Correct.
that you won't bring to court onto YouTube. So,
Correct.
okay. So it's Sean trusts that you're not going to post those videos.
I appreciate that. I have absolutely no reason to post anything on the internet about this case at all.
Okay. Well, then we get one down. But he's letting me know something else. All right, well, we didn't really accomplish very much except for maybe just knowing that we're going to proceed, and I don't think there's a whole lot of argument that's going to be required next week because you aren't moving and we're not moving, and except for we did I will take a look at that motion to strike and see how I need to amend it to bring it up to the third amended complaint and the answers. Oh, wait, Sean is mentioning that our argument is that we need the evidence for our case still. Oh, so he's right. And that was something that I wanted to talk to you about also, is by putting the case in abeyance, we're still going to subpoena all the same information. And so you're just creating more work that is unnecessary. And
well, you will have another lawyer representing the doctors or any other credentialed providers that you name, and that will be for that lawyer to raise.
But you'll be a third party. I'm not positive on this, but it seems like you're going to be like a third party that we have to subpoena rather than using the discovery that we were entitled to up until if they put the case in abeyance. And so,
Subpoena whatever documents you think are relevant. And if I disagree with the subpoena, then I can enter an appearance and file the appropriate motion at that time.
right, so you're saying go ahead and subpoena us. And I'm saying you were already supposed to give us this information. And that's what we're arguing about.
And I think that is the decision of the Claims Commission, because it is my position that all of my objections and arguments are well grounded, and we'll just have to find out what the Claims Commission decides.
Okay, so then we didn't really accomplish much, but thank you for your time.
Okay, you as well. Have a good weekend.
John's the smart one.